if there were no further questions regarding this amendment, pull up. All right. We have our Freedom of Information Act, or FOIA. This legislation seeks to enhance transparency within public institutions, particularly law enforcement, across the state of San Andreas. Citizens must be able to access any and all information relevant to legal proceedings that may impact them, especially when such data may be used in court. The legal foundation. The right of the people to access pertinent government-held information is fundamental to a free and fair society.
Here's the handout of the legislation as it is written.
Thank you, James.
To uphold due process and ensure governmental accountability, individuals must have access to the materials used or potentially used in judicial actions against them. Section 1. Scope and eligibility. Documentation created by any law enforcement... Sorry. There we go. Documentation created by any law enforcement or public agency may be accessible under this law, contingent on certain limitations. Article 1. Submission of records requests. All records inquiries must be submitted in writing to the San Andreas State Attorney's Office for process. Requester must first clearly identify specific documents or types of reports they are requesting. And second, provide valid contact information to facilitate correspondence and document delivery. Article 2. Processing and initial review. Upon receipt, the State Attorney's Office will issue acknowledgement of the request within 48 hours. If the request lacks sufficient clarity, the requester will be notified and asked to provide additional details. The State Attorney's Office will review the request to determine whether the requested information
Hold on, but it's only video access. No, anyone can
due to
view
one
it.
or more of the following classifications. Ongoing investigations, reports tied to active warrants,
wait, which one did you show?
charges, time, and fines related to the warrant are not exempt.
It's like a published version.
Proprietary
It's the
or
one
confidential
under
business information. Internal governmental deliberations. Sorry. Take a quick drink, guys. Give me a second. This is a lot to read.
That's perfect.
I'm gonna take a quick drink.
What the? Don't stand off the mic. I'll stand in for
RICO yet.
whatever I do.
Access it.
Okay. Let me try to do something then. Hold on.
Yes, sir.
I'm fucking drowned. Kidding. I'm kidding. Don't do that.
That's crazy.
All right.
Sorry.
See if that works.
Okay. Does anyone? Oh,
No,
wait.
I'm ready.
Wait, damn, that was quick. What the?
Done.
Don't say make a drink. Take a drink, then. I thought you were.
Take a drink.
Said take
Take a
Alright.
drink.
I said
Publish
make
that
a
copy.
drink.
Open your ears, Pablo.
Pablo, back up. I got this, bro. I got
My
this,
fault,
bro.
gang. My fault, gang member.
He also suffers from hearing loss.
All right, back to it.
Guys.
Internal.
Meeting.
Sorry. This one's a boring one, but it's necessary. Internal governmental deliberations. That's what I was trying to say. Records sealed under subpoena or court-issued warrant, and records that include identity of witnesses or victims.
After this should be RICO, I think. We'll see.
If no exemptions apply, the State Attorney's Office will coordinate with the appropriate agency and produce and deliver the file. If exemptions do apply, this is the new additions from the last time this was read. If exemptions do apply, the State Attorney's Office shall collaborate with a judge from the Court of Civil Equity in regards to possible redactions that could yield the targeted information without compromising the integrity of investigations or privacy of witnesses, victims, or businesses. If such redactions are impossible, the judge may deny the request. Article 3. For
Chat, this FOIA thing should help the fucking ARC for BBMC too. We can try and get the report that way.
3 days from the time of request submission, provide the
Just gotta be
document
crafting how to do it.
or written reason of denial.
I'll get you intro. Yeah.
When reports are finalized and not restricted by exemptions, they should be released promptly without any unnecessary.
Yeah, but I think Saturday's probably slower
They
to me.
require verification or sign off from the responsible reporting officer or originating agency prior to release. Article 4, Appeals and Dispute Resolution. There were minor changes in this section. If the request is denied or records are perceived to be improperly withheld, the requester may file an appeal with the San Andreas Department of Justice. A judge of the Court of Review will conduct a review of the denial and evaluate the appeal. Appeals must be initiated within 48 hours following a denial. Appeals can be submitted either through formal writing or in-person communication with any court clerk to be filed. A ruling on the appeal will be issued within 48 hours after the submission. Conclusion to this act: by enacting this law, the state of San Andreas affirms its commitment to transparency and public
I wonder
oversight.
RICO lasts so long, people might get bored listening to it, Timmy.
Individuals to access and challenge
It's
records
good,
that
though,
pertain to them.
because it makes it likely to
Reinforce the
pass.
trust in the judicial and law enforcement systems. I will now open the floor to the public for any questions regarding this legislation. EMS, sir.
Would there be a way that possibly get the warrants to the warrants page, not necessarily show the report as it does now, but to give information on the charges that are being faced by the people? Because like, if somebody's wanted for racing and fleeing versus somebody's wanted for murder, like, people should know that information. So
Would that fall under FOIA constitution? I feel like that's something we need to talk to
Yeah,
media
this-
about separately.
stuff.
Yeah, this doesn't. This wouldn't be addressed by Freedom of Information Act. Freedom of Information Act would be documents an attorney could request, or you could request personally about yourself relating to something that you are trying to pursue. As far as warrants and whatnot, there are certain
Actually, I can speak to that if you'd like.
SOPs.
I mean, real quick, I would say that is a what's the word? An IT issue. That it wouldn't be on our position to make any changes.
I can
Right.
also speak to that if you'd like.
Get you? Yeah, go ahead.
Yeah, go ahead, Vito.
Within the regards of showing charges,
I say I would have
let's
good
say,
input on
for
that.
instance, you have a gun that was found on the scene, and you're wanted for a hot gun. You don't want you to know those charges, so you can
Exactly.
Okay. One thing I want to
I feel like it's more powerful that way.
Listen, one thing. Hold on. One thing that I want to mention in this, the note when I mention reports tied to active warrants. Okay, the note says the charges, time, and fines related to the warrant are not exempt. That means those can be requested with a FOIA.
Whether or not you get them is up to a judge, though.
Right. So yeah, what?
But with
yeah.
the current open and active investigation, there's a high likelihood it will be denied.
Yes, I was going to say this act doesn't.
Somebody they have a warrant, you just can't tell them what's on the warrant. I think that's fair enough, right? Like it allows investigation.
At the end of the day, guys, we're giving a judge and the state attorney's office the ability to debate amongst each other. The judge in this case would be defending for the person looking for the information to get whatever possible information they can. That's why we added the section E to this, is so that there is a discussion, and if redaction can still yield the information that you're looking for, then you will get that information in a redacted form. See? That's why that was the huge concern last time we brought this forth, and that's why we brought these changes.
Have a good night. Have a good night.
So there would be more to it than just the state attorney's office saying yay or nay based off of circumstance.
I also think it's important to add that prior to FOIA even being considered, there was no way to get that information, right? I think this is us equipping you guys with the tools that at least it's potentially, it's a possibility, but I think it's important to keep in mind, it's not a guaranteed yes. It will not be a guaranteed yes. It has to be reviewed internally by SAO, DOJ, things like that. But the tool exists. The tool exists now for you guys to be able to at least pursue it, and then, we'll see how it goes for you guys.
All right. Was there any other concerns? All right. With that, I'll open the floor to vote on the Freedom of Information Act of San Andreas.
That'll be an aye for me.
I will say aye as well.
With that,
that-
the FOIA has passed and will be added into legislation.
I'll get some next time. I'll follow through.
You left it at her discretion.
All right, ladies and gentlemen, here we are to talk about the RICO Act Round 2. We've gone through multiple rounds of review. We've taken the public feedback from the last one, I believe it was 2 weeks ago.
Yeah.
Got input
There'll be a
from...
public version of it for everyone. To
Yep, I was going to say, Mr. James Maxwell here is going to share a little handout for you guys to be able to follow through as I read it through. All right, so let's kick it off. The Racketeer Influenced and Corrupt Organizations Act, aka the RICO Act. Preamble. This statute outlines the legal framework under which the state of San Andreas may pursue criminal enterprises operating as structured organizations. The purpose of this law is to deter long-term coordinated criminal activity while safeguarding individuals from unjust prosecution and ensuring fairness in both investigative conduct and legal consequence. Now, under legal foundation, the RICO statute is modeled after federal anti-racketeering laws and applies to criminal organizations that engage in a pattern of organized lawful acts. It empowers the Department of Justice to take action against criminal networks that act collectively in pursuit of illicit power or financial gain, while upholding due process and procedural oversight. Under Article 0, which is authorization for RICO investigation proceedings. Formal RICO investigation is initiated by State Attorney's Office with a compiling of evidence that is then presented to the Office of the Police Commissioner, which includes the Commissioner and the Deputy Commissioner of the San Andreas State Police for authorization to pursue. Section 1. Conditions for filing RICO charges. RICO charges may be considered only when the following criteria are met. A minimum of 6 individuals must be proven to be knowingly participating in the same criminal enterprise, with evidence linking them through shared leadership, planning, or coordinated execution of illegal activity. There must be documented, articulable evidence of highly organized criminal activity in furtherance of the criminal enterprise. The criminal activity must demonstrate a pattern of coordination, shared leadership, and organizational intent, and at least one act must be tied to financial gain, racketeering, or enterprise control. Article 1. Case submission process. A formal RICO case packet must be submitted to the San Andreas State Attorney's Office for review. The case must be co-signed by a command-level enforcement official and a State Attorney's Office and submitted to the Office of the Police Commissioner for final authorization. The RICO packet must contain a written case narrative establishing the link between all criminal acts, an organizational structure or hierarchy of the alleged enterprise, evidence logs including surveillance records, photos, and documented testimony, and a list of any proposed asset seizures or property designations tied to the criminal network. Article 2. Notification and defense rights. All individuals named in the RICO case must receive written notice at least 72 hours after the service of any related raid warrants. All discovery materials must be made available to legal counsel representing the accused, and each defendant must be granted an opportunity to appeal the RICO findings with formal trial proceedings and provide cooperations or admissions. Article 3. Limits of enforcement. The use of RICO may not be employed to justify or facilitate the blanket prosecution or collapse of an organization without individualized legal review, and the forfeiture or seizure of property not clearly tied to criminal enterprise operations. Sentences resulting from RICO convictions must reflect the proven criminal conduct and documented role of the defendant within the enterprise. Leadership convictions must demonstrate direct oversight or orchestration of illegal activities. Last, Article number 4. Oversight and judicial review. All RICO filings must be reviewed by a judge prior to being enforced. The Court of Reviews is at the discretion of the DOJ. The judiciary may return, revise, or reject RICO filings that lack sufficient legal merit or show signs of procedural overreach. And lastly, the RICO filings may not replace conventional investigative work or be used to bypass fair arrest processes. So in conclusion, the RICO statute grants law enforcement and prosecutors the ability to pursue organized crime effectively. When used properly, it ensures accountability among structured criminal enterprises while protecting the rights of individuals and preventing unjust or disproportionate prosecution. That, in sum, is the RICO legislation. For those of you who might remember the old version, we made many amendments based on the feedback we got previously, as well as we worked with the SAO's office as well as Commissioner and Senate to make sure that all parties are in line. Because as you can tell, passing a RICO is simply not a one-party affair. It is a three-check affair, and three parties must all align to ensure that this is successfully going to be pursued. But yeah, I think that's in sum reading the RICO legislation. Any feedback for the public? Going once? Going twice? Oh shit, chat!
Makes sense
All right.
to me.
We are good on that front. I guess we will now take votes.
Yep. Starting with you, Arya.
Aye from me.
And Elliot.
Shit, RICO's passed, chat!
And that is now passing legislation and will be posted on the court docket later on today.